All rise. Veuillez vous lever.
Back. Court officer, please put the matter on the record for today.
Thank you, Mr. President. Good morning, Your Honors. Situation in Darfur, Sudan, in the case of the prosecutor versus Omar Hassan Ahmad al-Bashir. Case reference ICC 0205-0109. For the record, Your Honors, we are in open session.
Thank you very much. I can see that there have been some changes in formation. I see.
Mr. President, Mr. Magliveras
Mr. Magliveras is no longer with us, okay. And also, formerly the ambassador for the Arab League is not with us anymore. And the AU, any changes?
Thank you very much, Your Honor. Ms. Negam and Ms. Omale will be joining us a bit later.
They'll be joining us a bit later.
Your Honor, I also noticed that Ms. Yolanda Gamara is not in court as well.
Thank you very much. Okay. Then we will, all that having been noted on the record, we will proceed. At 11 o'clock today, there will be a minute of silence around the court in memory of the late Kofi Annan, whose funeral is today in Ghana. And it is fitting that be done. We will also be doing that in the courtroom. As we all know, this court was established during his tenure as the Secretary General, and he was instrumental in the effort and continued to support the court after he left office. So we will be doing a minute silence at 11. Prosecutor, I understand you want to make some. I have a note here that you would like to say something.
Yes, Your Honor, I wanted to make some submissions on behalf of the prosecution in relation to the discussions yesterday on Group B, and I saw that basically we were turning to a new set of questions, and I wanted to make a brief set of responses on that.
There'll be some. We're not yet done with
Yeah.
Group B. There's some question from the judges still.
Yes.
Let's see how that goes.
Sure.
Whether that gives you an opportunity to
Of course.
make your submissions. Judge Ibanez would ask a question.
Thank you, Mr. President. Unfortunately, Professor Zimmerman could not join us in these hearings. However, I would like to ask the parties and participants if they have any comments on the potential applicability of the international law principle of abuse of rights, l'abus du droit, advanced by him in his written submissions, in the case of Sudan's behavior. Thank you.
Yes, Ms. Rokiv, and then after that, Mr. Latanzi.
Judge Iban, yes, I'll be very brief. There really is no international principle of abus de droit. It's found in pockets of international law, but very specific pockets. The main one being that, for example, in the law of the sea and various other areas like that, a state is in very narrow areas not permitted to abuse its right in relation to its own territory or its own maritime spaces to the detriment of other states. There's a provision in the WTO. But this is something on which there has been much academic debate and scholarship. It is not a general principle of international law. That is the first point. The second point is, does it not presuppose that Mr. al-Bashir is guilty to say that Sudan is behaving abusively in claiming immunity in relation to him? Sudan has a perfect right under international law to claim immunity on behalf of its sitting head of state, only if we assume that that head of state somehow committed a crime, would that be an abuse? And even were it the case that he had committed a crime, it's not an abuse. As the International Court of Justice made perfectly clear in the arrest warrant case, they are not providing for his impunity. There is nothing to say that Mr. al-Bashir may not fall from power, as happened in many states, and be prosecuted. There is nothing to say that at some point, in some other way, he will end up in the dock. But to say that it is an abuse of right to assert what is Sudan's perfect right under international law seems to me rather extraordinary, and to put the cart before the horse. But coming back to the main principle, there is no general principle of abuse of right in international law.
But if the idea is that Sudan is under an obligation of full cooperation, which obligation, assuming, again, here we have to make some assumptions, assuming that that obligation of full cooperation includes a duty on Sudan to surrender its officials to the court.
Mm-hmm. Mm-hmm.
Can they later on assert immunity in that regard,
Right.
Without triggering questions about whether there's an abuse?
Sure. Well, Mr. President, I think that assumes rather a lot. It assumes that there is actually an obligation to waive his immunity.
I'm saying,
Sure.
assuming that.
Absolutely.
I already said that.
But of course, the International Criminal Court is based on the principle of complementarity. Sudan, in its cooperation with the court, may, for example, be obliged to prosecute him at home or something like that. I think even that's going too far. But I think it really is stringing together rather too many tendentious strings to say it's an abuse. But anyway, it's not the case that Sudan would be relying on its own illegality in a way. It's got two separate things here. It's refusing to comply, okay? But on the other hand, it does have a perfect right to assert immunity. So let's just say you, and I'm sure that this would never happen, you steal from me £10. Mm-hmm. But actually, I owe someone else £10, right? I still have a right to get the £10 back from you, even though I really owe someone else £10 as well. The two things are separate, okay? That person may have a grievance against me, but I'm still entitled to ask you back for my £10.
But what if it's the same £10 you're talking about?
Sure, I'm still entitled to ask them back from you, and then I will have to give them to that person. Simple as that.
Just, Professor Kifi, I have listened to you very carefully. But however, can it be said that there is a doctrine of abuse of right in the international arena?
Well, with all due respect, Judge Ibanez, that's precisely what I just said. There isn't. There are specific rules.
You said there is no...
There is not.
An international principle.
Not a general
principle.
International
But it is
principle.
different to a doctrine. Could it be said that there is a doctrine, that it exists?
I'm wondering if you could explain the difference to me, actually, because I'm not sure what the difference is.
No, we won't do that.
No, I'm not. No, I don't understand the question. I don't.
The point is this: you can simply say you've got nothing else to add to it. If you say that you've spoken to the absence of a rule of international law in that regard.
Sorry, maybe I just phrased it the wrong way. I was actually trying to clarify what the question was. I didn't mean it, I'm very sorry, in any insolent way. I was just trying to work out what I was being asked. I'm very sorry if that came across the wrong way, and I apologize unreservedly. I was trying to ascertain what the question might be getting at. But if the court is satisfied, I'll happily sit down.
We can leave it at that.
Sure,
Thank you. Mr. Tanzi, please.
Ici, on est pour appliquer naturellement le statut de Rome. On est ici pour appliquer le statut de Rome. L'article 21, paragraphe 3, je crois, prévoit que la Cour applique aussi les principes généraux du droit. Et l'abus de droit est un principe général du droit. Et donc, il est applicable sur la base du statut. En premier. En seconde, il faut dire que l'obligation du Soudan de coopérer pleinement avec la Cour n'est pas présumée. Elle a été bien déterminée par la Cour même. Donc, on pourrait bien dire que de ne pas coopérer, c'est un abus de droit. Merci.
Good morning, Your Honours, and thank you. Perhaps unsurprisingly, we would agree that abus de droit is potentially relevant to Your Honours' consideration, and we would also agree with Ms. Latanzi's comments just now. If first I can take Mr. O'Keefe's point about the question as to what the abuse is, we would also agree with the premise of Your Honour's question to Mr. O'Keefe, that here the relevant abuse would be Sudan's failure to cooperate fully with the ICC under Resolution 1593 and the terms of the statute. And we would say that the analogy between two different people and the £10 is not an apt analogy, because here Sudan has failed to cooperate with the court by arresting and surrendering Mr. al-Bashir, and then they would seek to rely upon the immunity that they cannot rely upon directly before the court in their dealings with a third party, Jordan, which is an ICC state party acting on behalf of the court.
So
we would say
same £10.
it's the same £10 and actually owed to the same person. We have Jordan standing in between in this case as a sort of intermediary, but we would say the fundamental obligation which is relevant is ultimately Sudan's obligation to the court, and it is trying to, if you like, rely on its inability to raise that immunity before the court, but to raise it instead before Jordan. And that puts Jordan in the invidious position that Jordan relies upon. Just turning to the second point about the status of abus de droit as a doctrine, we would not perhaps get into the intricacies of the status of abus de droit as a matter of general international law unless we really had to. But we would draw Your Honour's attention both to Resolution 1593, which says cooperate fully, and also Article 86 of the statute. Now we'll come to this a little bit in our submissions on Group C, but in short, our view would be that the kind of almost equitable principle which underlies Article 86 is the same sort of basic notion which underlies abus de droit, as well as other doctrines such as the notion of coming to the court with clean hands and so on and so forth. So we would say not only, as Ms. Latanzi said, you might find abus de droit as a general principle of law common to the major legal systems of the world for the purpose of Article 21(1)(c), but you might also find that same notion already in the statute in Article 86. Thank you, Your Honour.
Thank you very much. Yes, Mr. Tladley. I also note on the record the Ambassador is Negmis with us now. Please proceed. And after you, Mr. Murphy.
Well, thank you very much, Your Honour. We, in fact, do address the issue in our written submissions, and I believe we also addressed the issue in our oral submission. The point that we made in our written submission is, so we referred to, for example, the statement by Sir Hirsch Lauterpacht, who cautioned that even to the extent that it is used, it ought to be wielded, and I believe the words that he used were with studied restraint. Sir Ian Brownlee himself had said, though it might well be an instrument for progressive development, it in fact did not exist in positive law. We also stated that to the extent that it might be possible to rely on the doctrine of abuse of right, in the instances in which it has been referred to, it has always been in a bilateral context. where the state purportedly abusing its right has done so to the detriment of the state claiming an abuse of right. Relying on it in this context would require states to be treated as enforcers of UN Security Council resolutions when they have not been mandated to do so by the Council itself. In other words, and I guess this to some extent goes to the 10-pound analogy, the doctrine cannot be used to avoid obligations owed to one state on account of the fact that the latter state has not complied with obligations owed to other states. I will just make a final point, which is not in our written submissions and which we did not allude to in our oral submissions. In the course of the work on state responsibility and codifying the rules on state responsibility, there had been a proposal on an abuse of right doctrine, and it was not included in the draft articles on state responsibility. And I think that that's a point that I think ought to be borne in mind.
And when I ask this question, Mr. O'Keefe could also respond to it later, and also perhaps Mr. Murphy when he speaks. But the question is this, Mr. Lantley. I think you're bringing in the notion of responsibility of states for internationally wrongful act is quite apt. That's one very apt way to look at, to examine this question. And it comes in this way. A state has a duty to fully cooperate. It has not done so. And again, on the assumption that fully cooperate also includes, your head of state has no immunity. At your instance, right? Not outside. Basically, Sudan's head of state cannot enjoy immunity before this court. Good. But he goes to Jordan, and Jordan says, well, sorry, sir, we have to send you to the ICC. And Sudan goes, no, you can't do that. You've done it, we're going to sue you at the ICJ and claim reparations. The question is, how does it work when this claim for reparation occurs at the ICJ? So yes, we have not complied with our obligation placed under us, but we're going to sue you because you've done something to violate our immunity that we don't have in our own right. That would be one way to look at the abuse of right argument. We call it abuse of right in different systems, they call it something else. In common law, I think there's another notion, ex turpe causa non oritur actio. Out of one's wrong, a right of action cannot arise. Can a right of action arise for Sudan against Jordan in that kind of scenario?
Well, it seems clear to us, Your Honor, that indeed it arises. Right of action arises, and the reason is that there is an obligation under customary international law which is unrelated, completely unrelated to the duty to which you're referring to under operative paragraph 2. And so in that context, that right remains, and there's nothing in operative paragraph 2 that takes away this relationship, this customary international law relationship relating to immunity. So of course, the right of action remains.
And no concerns about clean hands?
Excuse me, Your Honor, could you repeat that?
I said no, Sudan in those sorts of circumstances need not worry about doctrine of clean hands. They can boldly go to the ICJ and claim reparation.
Well, I think so, and I think the reason again is because these are unrelated obligations. It's not as, so that's the point. Because they are unrelated obligations, I don't think that the doctrine of clean hands would apply.
Thank you very much. Mr. Murphy first, and then back to you, Mr. O'Keefe.
Thank you, Mr. President. If I can, I would begin by noting that, again, this is not actually an issue on appeal as far as Jordan would be concerned. We didn't see anything about the doctrine of abuse of rights in the pretrial chamber's decision. We didn't see anything on this doctrine in any of the prior pretrial chamber's decisions. We didn't address this in our request for appeal. we didn't address this in our appeal brief. The first time this issue is raised is not even by the prosecution, but by Professor Zimmerman. And so I just wanted to start by highlighting that this is, again, a part of the concern that we have generally about Jordan being held accountable for theories that were not articulated until about 6 weeks ago. But to address the issue on the merits, it's even unclear in this room what right is supposedly being abused. If I heard Professor Lattanzi correctly, she believes that Jordan abused a right of some sort. I believe I heard the prosecution say, no, we're talking about Sudan's abuse of its rights. We would submit that Jordan has not abused any rights whatsoever. If the question is, has Sudan abused a right, that then presupposes that there is a right, that there is a head of state immunity. To us, the doctrine would necessarily require you to assume that there is a head of state immunity and that Sudan is using that in a manner that is somehow improper, abusive, and so on. To us, that then answers the case to us. In fact, we feel that the application of this doctrine is rather question-begging. It's basically just another way of saying, is Sudan acting in accordance with the law or not? And we fully accept that's an issue here, but talking about it in the context of abuse of right does not help. And I would just finish by saying—
And you're also telling us to be careful how we use that in a way that negatively affects Jordan.
Well, I think so. To the extent that there's something to do with Sudan and abuse of rights, how that then applies to Jordan is certainly not obvious to us. And we have some doubts about the doctrine being a well-settled doctrine of international law. Even in the context of unclean hands in the River Meuse case, it's a single separate opinion. It's not the court as a whole. States have repeatedly approached the International Court of Justice invoking this doctrine, and the court has not habitually accepted it. They tend to view it as question-begging and saying instead, let's just go directly to what's at issue in the case.
Mr. O'Keefe, and then...
Mr. President, I would just affirm what was last said about the doctrine of clean hands. That, too, is an incredibly contentious point in international law. Let me give you an example. Nicaragua went to the International Court of Justice in relation to the United States of America. Now, the obvious contention was that Nicaragua itself had sent troops into Honduras and Guatemala, but the International Court of Justice was perfectly clear that that was a separate issue. What was at issue in that case was the United States' action against Nicaragua. Secondly, the doctrine of abuse of right is not found in the common law. Famous case of Bradford and the Prickles and the Bradford Corporation stated that. It's a doctrine found sometimes in equity and certain specific doctrines of the law of equity, but it is famous amongst comparative lawyers that it's not found in the common law. So it's not even a general principle of law recognized by civilized nations.
Yes, Mr. Tanzi, and then Mr. Cross later.
Je m'excuse de demander encore la parole, mais je voudrais avant tout répondre à la première objection du représentant de la Jordanie et le fait que la pertinence ici de l'abus de droit ne se pose pas devant la chambre d'appel parce que ce n'est pas une question qui s'est posée en première instance. Et donc, il faut quand même rappeler le principe Iura novit curia, et qui vaut surtout pour une chambre d'appel. Et donc, c'est à la chambre d'appel, selon moi, de s'occuper de toutes les questions qu'elle pense puissent l'illuminer dans l'application du droit dans cette affaire. Après, la question de l'abus du droit, si c'est l'abus de la part du Soudan, de la part de la Jordanie, je pense les deux, on pourrait hypothéser, appliquer ce principe général du droit sur la base de l'article 21C au manque de coopération par la Jordanie et par le Soudan. Je comprends que la Jordanie puisse dire le Soudan n'a pas le droit, il n'est pas parti au statut, il n'a pas, je le contexte qu'il n'a pas l'obligation de coopérer, mais je pense que la Jordanie est consciente du fait que la Jordanie, qu'elle a ratifié le statut, qu'elle est obligée par le statut, par toutes les normes du statut et par l'obligation de coopérer, et qu'elle ne l'a pas fait. Ne l'a pas fait par rapport à une décision de la Chambre, de la Cour, qui est dans la compétence de la Cour de prendre. Merci.
Thank you very much. Yes.
Thank you, Your Honours. If I might just add a couple of points of clarification in response to Mr. Murphy's comments. The first is that, yes, as Your Honour alluded to, we would understand the doctrine of abuse of rights being relevant if we assume that there is a relevant obligation to accord immunity to Mr. al-Bashir. So if there is no such obligation, then obviously, from our point of view, we wouldn't be getting into this discussion. So this is an argument which becomes relevant if Your Honours decide that there is prima facie an obligation to accord immunity to Mr. al-Bashir for these purposes. The second point is perhaps just to come back on how we might see this analysis fitting in to the analysis that this court is obliged to undertake. And of course, under Article 98.1, before proceeding with a request for arrest and surrender, this court has to ask itself the question whether or not the requested state is obliged to afford immunity to a third state. So this court has to delve into, if you like, the bilateral relationship, in this case between Jordan and between Sudan. So therefore the doctrine is relevant because it comes to the question whether or not Jordan would be placed in the invidious position of committing an internationally wrongful act by arresting Mr. al-Bashir.
Did you say the doctrine is relevant or irrelevant?
Relevant.
Relevant, thank you.
Thank you, Your Honour. In other words, therefore, what the court has to do is look to see whether or not Jordan would commit an internationally wrongful act vis-à-vis Sudan, and here we would say it would not, if Your Honours were minded to go down the abuse of rights road, because Sudan cannot rely, for the purposes of any action against Jordan, with regard to arresting and surrendering Mr. al-Bashir for this court, because it is itself under an obligation to arrest and surrender Mr. al-Bashir to this court. And that would be the link. So yes, it's bilateral, but Your Honours are taken to that through 98.1. Thank you.
Thank you very much. Judge Hofmansky has a question.
Thank you, Mr. President. I have a question related to the position taken by Jordan yesterday. Is it your position that even if Article 27 could be said to apply to the reference situation, in the case Darfur, it does not apply to the reference state, in this case Sudan? It's a little bit difficult to understand for anybody who saw the political map of Africa.
Thank you, Mr. President. Thank you, Judge, for that question. Our position is that paragraph 1 of the Security Council's resolution refers a situation. It places that situation, and more specifically, the crimes that occurred in that area within the jurisdiction of the court. It does not in some fashion trigger some unique status for any particular state, including Sudan. That is our position.
When you say some unique status, can you?
Well, there have been various characterizations put forward. I think UNSC situation referral state as a category, or quasi-state party, or something, but all of that seems to be saying that Sudan as a state, by virtue possibly of paragraph 1 or paragraph 1 in conjunction with paragraph 2, somehow transforms the state of Sudan into some unique relationship with the Rome Statute, and we just don't think that's what paragraph 1 accomplished.
Yes.
Just to clarify one point, and it's a question of how we use the term UN Security Council referral state. That is a shorthand by the prosecution, and I think that's clear in our submissions. That is a shorthand term meant to cover those states, i.e., in this case, Sudan, who are bound to comply with the court because of the referral. We're not inventing a new category of state. It's a shorthand term, a quick term for saying that it is a state which is obliged, because the situation on its territory has been referred, it's a state which is obliged to comply. In the same way, we say, as a state party would be obliged to comply, and a state making an Article 12.3 declaration. And we mean no more than that by the term. We're not making, and also we're not making Sudan magically into a state party. We're saying that the court was right to find that the triggering of jurisdiction made the obligations in the Rome Statute incumbent on Sudan as if it was in the position of a state party. I think that was probably clear already from my submissions, but I thought it was worth adding again.
And Mr. Murphy, on that, I don't know whether you've spoken to this before, but there's been a question that I have been putting to counsel. This discussion on abuse of rights somehow brings it back in, though not for purposes of abuse of rights as such, but also the question has connection to the discussion we ended at yesterday on the meaning of urge, whether urge somehow can mutate into an obligation. And here the issue is this. If the, again, part of this thing has to, my concern here, it's about the characterization, whether we say Security Council waived immunity and all that, it all goes there. But the point isn't as such what we call it, as much as the effect of it, perhaps. And if the effect, we are talking about negation of a claim, that claim being immunity, and that negation occurring at its base, at the base of that claim or right, and that base being Sudan, does it really matter how that negation occurs, whether we call it waiver of immunity or not? If the point is that by operation of law, applicable law, be it Security Council Resolution 1593, or in combination with the ICC statute, we say, all of us in this room, if you agree to that Sudan does not enjoy immunity in its own right as such in Sudan, upon crossing border, does that now revive into an immunity by mere fact of Mr. Bashir has crossed the border into another territory? So at home, Bashir does not have that immunity vis-à-vis the ICC, but by mere fact of having traveled outside Sudan, somehow what he doesn't have at home becomes something for him overseas that will now trouble the exercise of jurisdiction of the court.
Thank you, Mr. President. If I understand the question, it seems to be assuming that we have a single immunity here that operates in a lot of different places. And I think the best way to think of it is a Sudanese official might have immunity under the law of Sudan with respect to the jurisdiction of Sudanese courts. A Sudanese official might have immunity vis-a-vis the jurisdiction of this court. A Sudanese official might have immunity with respect to the exercise of foreign criminal jurisdiction, which might arise under international law. It might arise under a 1953 convention, a pact of the Arab League, and so on. So I think one needs to ask the question in these different contexts. We would submit by the referral in paragraph 1 of the resolution, it is clearly the case that if the president of Sudan were before this court, he would not be able to invoke head of state immunity. Article 27, paragraph 2, we think makes that clear. But it's a different question, a very different question, if he is in a foreign criminal jurisdiction such as Jordan. There I think you have to then run a different kind of analysis that we don't think paragraph 1 referred to. We think that maybe you could say paragraph 2 in some fashion is referring to this. The argument would be that by deciding that Sudan must cooperate, that ipso facto waives immunity even in foreign criminal courts that Jordan is supposed to be cognizant of and take account of. But our position would be actually paragraph 2 uses the words urging with respect to third states. And when you combine that with the existence of immunities that I would note are immunities that the Arab League views as owed to the League itself. And this relates a little bit back to the abuse of rights doctrine. If Professor Latanzi is continuing with her claim that Jordan abused its rights, then I think it's a claim that the Arab League is abusing its rights as well.
Thank you, Your Honors. I think that in this case, we're talking a lot about the urge language, but I think in this case it doesn't matter. I think it could conceivably matter if there was a case where a non-party state arrested al-Bashir. In this case, Jordan is a state party, so they're already bound by the statute by virtue of being a party. Even if there were a case with a non-party state, what I would suggest is even there, the urge language doesn't matter. But that's because of my view that the UN Security Council removed al-Bashir's immunities vis-a-vis the ICC. Al-Bashir has no immunities opposable to the ICC. Therefore, even for a non-party state, they would be committing no internationally wrongful act. So in a way, I think that the urge debate might not matter.
Mr. O'Keefe and then Mr. Ruston was...
Just a very, very brief point, Mr. President, and forgive me if this is absolutely unnecessary to say, but it was thrown up by your last question to Counsel for Jordan. I think I should make it absolutely clear just to everyone present, and perhaps you already know this, but international law says absolutely nothing as to whether a head of state is immune in his or her own state. International law says nothing as to whether any other state official is immune from the jurisdiction of his or her own state. State doesn't owe an obligation to itself. International law deals only with the situation that you said of a head of state vis-a-vis a foreign state, or a head of state vis-a-vis the court. So whether Mr.
But the international law does know whether the head of state has immunity before an international court.
Sure, that's all I'm saying. Yeah, but all I'm saying is that, I don't know, and perhaps I misunderstood the premise of your question. International law says absolutely nothing as to whether Sudan must accord or must not accord Mr. al-Bashir immunity in Sudanese courts. The laws of some states provide that the head of state is immune while he or she is in office in their own state. The laws of other states don't. That's national law. I just thought I would make that clear. It's neither here nor there.
Thank you. Mr. Raston, you...
Actually, Your Honor, Ms. Brady will address one point, and then I'll address the second point if you permit.
Fair enough.
Thank you, Your Honour. Mr. Robinson raised an important point, and it's something that the prosecution wanted to come back on from yesterday's discussions. And the question very much in the discussion yesterday was, how does Resolution 1593 operate in terms of the obligations on the various categories of state? Now, for Sudan, I think we're all agreed. The resolution clearly obliged Sudan in relation to the Darfur situation to cooperate. But where we disagree with Jordan and some of the others is that it's not an obligation to cooperate just in some kind of ad hoc way, but rather in the way that the pre-trial chamber majority found correctly, subject to the same obligations as a state party, including the fully cooperate obligation and not being able to raise head of state immunity. That's category one, only covering Sudan. What about state parties? And this is where the case is, this is where the action of the case is for Jordan and other state parties. They're not specifically named in the resolution, although I take your point, Your Honour, you made yesterday that they're negatively discussed by virtue of the fact that paragraph 2 states, while recognising states not party to the Rome Statute. So they're sort of negatively, by implication, they're discussed. But they're not specifically named. But, Your Honours, it's no wonder that they're not specifically dwelt on in the resolution, because they're already bound by the Rome Statute to comply, by virtue of being a party to the statute, to comply with the obligations in the statute. So for them and for the prosecution, the position for them is clear. It's as the majority found. They're obliged to comply with and respect and comply with the Rome Statute. That means when they receive a request for arrest and surrender of a state, head of state, that is also bound to comply with the statute, and again, whether that be another state party, whether that be a state bound to comply because of a Security Council resolution, or because they've made an Article 12.3 declaration, that state party cannot turn to head of state immunity and claim it as a bar under Article 98. That's the facts. Now, I finally want to turn, because we got a lot into the question of non-state parties yesterday. That is, non-state parties apart from Sudan. And again, I think many in the room have noted that that's not the situation we're here today about. And this word in paragraph 2, urge, that we discussed at length yesterday. Now, I think I made it clear already in my submissions earlier in the week, they are not bound. Non-state parties are not bound to comply with a court request to arrest and surrender. That's pretty clear. They're strongly encouraged to do so. And in answer to my colleague, Mr. O'Keefe, yesterday, my reference to Blaskich was not meant to suggest otherwise. I merely mentioned Blaskich to highlight the potential breadth of the Security Council Chapter 7's powers, and to answer the President's question about the distinction between mandating and coercive measures.
And the reason I also interrupted you when you brought in Blaskich was whether we could look at Blaskich in the context of perhaps what the Appeals Chamber Revised CTY meant by states who bore the coercive effect of the Security Council resolution there under contemplation. I mean, could Croatia be considered to be part of the situation state state that would bear that coercive effect, in which case the obligation on it may well be different from that upon by other UN member states?
Well, Your Honour, clearly the binding order that was made by the trial chamber and confirmed by the appeals chamber was directed at Croatia. So the holding of the case concerned that state. But as I perhaps not so successfully tried to say the other day, is that it had the cases stand for a wider proposition in the facts of the ad hoc tribunal for the former Yugoslavia, and I'm not suggesting that this is the case necessarily here because of the terms of the resolution, at least for non-state parties, that it had wider effects for all member states of the UN, and I pointed to some of the paragraphs of that the other day. But I think, you know, for non-state parties, Blaskic has to be read within the confines of the ICTY resolution and the specifics of that case. Your Honours, so going back to non-state parties, they're not bound to comply. That's not our position. But what we're saying is it's not necessarily the end of the story, because a non-state party may choose to voluntarily comply. And that's a hypothetical situation where they do so. And the question is, what effect would that have for his immunities if they do choose to comply? And I think I described this the other day as it's not the case before us, and it is a difficult question. But in our view, in the event that a non-state party voluntarily decided to cooperate with the court and arrest and surrender Mr. al-Bashir, they may, and I put it no more highly than that, they may be in the same position as state parties, and if so, then his head of state immunity would likewise not be opposable. But as I said before, it doesn't arise on the facts, and as well, in light of the position I've just taken, respectfully, we don't think we need to make a further answer to the question about whether the urge in Para 2 does amount to a license or excuse or defence permitting derogation from immunities that Sudan may otherwise enjoy. Thank you.
Thank you, Mr. Ruston, briefly, and then Mr. Kreis.
Thank you, Your Honour. So also just to complete just our discussion on terminology, and the reason that we emphasised just now the difference between state parties and non-state parties, and whether or not they could voluntarily consider to cooperate, is because we have this discussion about whether or not there is a relevant immunity that would be engaged that Sudan can claim. And this goes back to a discussion that has repeatedly come up, and I think we discussed this term in different ways, the parties involved and the Amici, in terms of what is meant by the notion of domestic criminal jurisdiction. Since this is, of course, to what personal immunities attaches under international law, under customary rules. It attaches to the exercise of foreign criminal jurisdiction, to domestic criminal jurisdiction. So the question is, does an ICC surrender process that is channeled through a national authority constitute the exercise of domestic criminal jurisdiction? And Jordan made the point, I believe, that because their courts will be engaged in that process, because their police will be engaged in giving effect to the warrant, that this necessarily triggers the exercise of national criminal jurisdiction. But we just wanted to emphasize the distinction that the mere fact that national courts or the police apply domestic law, necessarily, that they apply domestic criminal law and domestic criminal procedure, this does not mean that they are asserting, that its national courts are asserting the exercise of domestic criminal jurisdiction against Mr. Bashir. For the reasons that we said previously, we believe that they clearly are not. It is the court, of course, that is asserting criminal jurisdiction, and as we said, also Article 59 does not permit the national courts to consider themselves to be in that position. And just lastly, I think the arguments that Jordan has put forward in its statement would also create an absurd outcome by completely extinguishing the relevance of the ICJ's distinction in paragraph 61 of the arrest warrant judgment, to which we keep on referring. Because it would mean that although the warrant is issued by this court for its own criminal process, the execution of that warrant, which is mandated by the statute, triggers automatically the application of customary rules in the way that, as the ICJ found in the case of Belgium, the mere issuance of a domestic order or warrant to give effect to an ICC warrant necessarily is unlawful, because, as we recall, the ICJ held that the mere issuance by Belgium of the domestic warrant against a person enjoying personal immunities was unlawful. So we believe that this outcome would be absurd.
While you're on your feet, Mr. Raston, and also please, everyone else in the room, if we can look at Article 4.2, Article 4, Paragraph 2 of the Rome Statute. We've already discussed, and Mr. O'Keefe has spoken to Article 59 of the Rome Statute, and he and Mr. Raston joined issues on that. But looking at Article 4.2, can it help us get anywhere in our thinking process in this case? 4.2 says, quote, the court may exercise its functions and powers as provided in this statute on the territory of any state party and by special agreement on the territory of any other state, unquote. Now, we want to contrast what is being said there from what is being said in Article 3.3, which is the court may sit elsewhere whenever it considers it desirable as provided in the statute. They're not saying the same thing. I'm more interested in 4.2. Does a combination of 4.2 and 59 help us answer that question about jurisdictional proxy, whether or not it is what's happening here?
Of course, Your Honours, I'm speaking on my feet, so forgive me if I may ask to return to this point. But I think the term functions and powers in Article 4.2 is interesting to the extent that it also mirrors...
Why don't you do this? Why don't you think about it?
No, I can give you a preliminary response, if I may. Yes. I think I just want to draw out one further interesting point, that those terms, functions and powers, are also reflected in Article 87, 5 and paragraph 7 of Article 87, that it relates to the failure of a state party to cooperate, which has the result of frustrating the court's ability to exercise its functions and powers under the statute. So cooperation gives effect to the court's functions and powers, and the state can be held in non-compliance if it's failed to give effect to the court's functions and powers. So I think indeed, Your Honour, there is something beyond the mere ability of the court to sit in a foreign territory that is reflected in Article 4.2, and it is the fact that it's, the court's functions and powers are given effect through the mechanisms of state cooperation. Yes, exactly.
State party.
Yes, yes, exactly.
All right, thank you very much. Mr. O'Keefe, Mr. Krebs first. No, Ms. O'Keefe, I'll come to you later. Mr. Krebs first.
Mr. President, I'm extremely conscious of the time constraints under which we are operating here, and therefore I have so far not engaged in the fascinating debate about the precise legal effects of Security Council Resolution 1593 for non-state parties to the ICC statute other than Sudan. I have not done so because up to that point I'm still not entirely convinced to what extent this question is relevant to our appeal. But as it has been argued so extensively, I only wish to make one short observation. I wish to refer this honorable bench to pages 342 to 348 of Dapo Akande's article in the Journal of International Criminal Justice, Volume 7, year 2009. In my humble view, what my distinguished colleague and dear friend Dapo Akande writes there is spot on with regard to all these issues. I just want to place on the record I fully subscribe to those positions, and they entirely support what Darrell Robertson has just said in his brief intervention, and Helen Brady. Thank you, Mr. President.
Thank you. 1 second, please. Thank you. AU, please, and then we'll come to Mr. O'Keefe.
Thank you, Your Honor. I have been listening to the conversation very carefully, and Your Honors, it strikes me as that the prosecutor's position with respect to the whole discussion we've been having this morning brings us in many ways back to a question that occupied us quite a bit yesterday, framed in the terms of necessary implication. And so what I propose to do is to just offer a number of observations, Your Honors, that might be helpful in the context of the decision that you have to make on Jordan's appeal. Because in many ways, that assumption of the OTP with respect to Sudan's obligations really turns on this issue. So here I have about 4 points that I would like to make very briefly. And I want to also cite some authorities as well along the way, because of course those will be helpful, I think, for the chamber in dealing with this particular question. So the first point is this. In my humble submission, in order to attribute a meaning to a provision, the text itself must refer to the meaning either expressly or by necessary implication. Expressly or by necessary implication seems to be a phrase that is used across the ICJ, the ICC, and even in the ILC. It may suggest that the standard for reading a meaning into the text by necessary implication is so high that in effect it must be as if it was done expressly. And I say this because if you look at what the International Court of Justice said in aerial incident of July 27, 1955, at page 144, the court states in respect, this is a dispute between Bulgaria, Israel and Bulgaria, and I'm quoting now, "These were events," referring back to the events in the case, "to which Bulgaria, which became a party to the statute, only as a result of its admission to the United Nations in 1955, was not privy. It would be permissible to have reference to those dates in respect of the application of Article 36, paragraph 5, only if that provision had referred thereto expressly or by necessary implication," close quote. That's the first authority, Your Honors. The second reference was by Your Honors, Judge Boyosuji, in the context of the Ruto case. Paragraph 106, separate further opinion, 3rd June 2014, and I quote, "It is, in my view, both appropriate and desirable to maintain the same approach in the formulation of the standard of proof for purposes of no-case submissions made at the close of the case for the prosecution. It is to be recalled that the review of authorities conducted above indicates ample support for such a lower standard, either by explicit pronouncement of the highest national courts or by necessary implication." There is more, Your Honors. The third one, from the ILC, commentary on the draft Article 69 of the VCLT in the Yearbook of the International Law Commission, 1964, Volume 2, ACN 4173, page 202. International Law Commission says, "Moreover, the jurisprudence of the court," the ICJ of course, "contains many pronouncements from which it is permissible to conclude that the textual approach to treaty interpretation is regarded by it as established law. In particular, the court has more than once stressed that it is not the function of interpretation to revise treaties, or to read into them what they do not expressly or by necessary implication contain." Close quote. ILC 1969 VCLT discussion. That was the first point, Your Honors. Second point, in my submission, interpreting a treaty provision then, in light of these authorities, by necessary implication, means that such interpretation is not open for other interpretative possibilities. I think we can all agree here, whether it's the prosecution, whether it's Jordan, whether it's the amici on all sides of the issue, that in fact we are saying there are different interpretive possibilities. That is, in fact, I think I can take that as a fair reading of the room. So in a sense, it suggests this idea of necessary implication, the claim cannot be sustained. And there is an authority here that's also useful because it comes from the ICC itself. This is in the Blé-Goudet case, a decision from the 1st of November 2016. And of course, there's a long paragraph 80. And I just want to go directly to the elements because they are from the appeals chamber. This is the appeals chamber decision. The appeals chamber does not consider that the necessary implication of the trial chamber's reasoning is that the evidence of all crime-based witnesses may be introduced under Rule 68.3 of the rules, and I'm going to skip the next sentence, but then it says, no general conclusions can be drawn on that basis alone. Many of the reasons warranting the hearing of testimony viva voce in its entirety may apply equally to crime-based evidence. Such reasons may include, and the chamber gave some examples. Again, paragraph 80, appeals chamber in the Blé-Goudet case. Then, of course, we come to Bemba, partly dissenting opinion of Judge Eboya Suji, 17 June 2015, paragraph 9. And I quote, the necessary implication of these omissions regarding the confirmation decision is that the Rome Statute contemplates the DCC, document confirming charges, of course, as the primary instrument which notice is given to the accused. This is the principle of international criminal law well settled before the ICC opened its doors to judicial business. Your Honors, Bosco Taganda, judgment of the appeals chamber, paragraph 40, 22nd March 2016.
Mr. Jallo, are you about to finish?
Sorry, Your Honors.
Are you about to finish?
Yes, Your Honors. I only have two further points, very brief. And I maybe would just cut just for the sake of time, Your Honors, because indeed Mr. Tladi wanted to react very quickly, if it would be permissible to the court, to Mr. Ratstan's point. So let me move on to the third point. So this point here was the second point relating to the idea of the standard being so high, it cannot be left open, it cannot be used where we are all accepting that there are separate different interpretive possibilities. And again, here we are, I think, in agreement that there is, whether it's with respect to 1593 and the obligations of Sudan and the obligations of non-parties in respect of arrest and so on. So I'm going to move on very quickly to the last 2 points, Your Honors. And
can you make that in 1 minute, please?
Okay, 1 minute. Yes, I can. I'll do my best, Your Honors. So essentially, I will come down to the conclusion of the ICJ, and let me just use this, where in a judgment involving the case concerning rights of nationals of the United States of America in Morocco, on the 27th August 1952, page 196, the court says, in these circumstances, the court cannot adopt a construction by implication of the provisions of the Madrid Convention, which would go beyond the scope of its declared purposes and objects. Further, this contention would involve radical changes and additions to the provisions of the convention. And that's why I'm citing to this. And it concludes, it is the duty of the court to interpret the treaties, not to revise them. So, Your Honors, in essence, the result of treaty interpretation by necessary implication must not go beyond the prescribed purposes and objects, and I will submit this is in relation to 1593 as well as the paragraph 2. Thus, in my view, it is not for the court to essentially, by necessary implication, read in obligations for Sudan that were not explicit from the decision of the Council in light of Article 13b. So if Your Honors will permit me, I'll pass the floor to Mr. Tladi. Thank you very much, sir.
Can we leave it at that, and we maybe have another opportunity to return? But let's now go briefly to Mr. O'Keefe. After that,
briefly is the word.
Briefly, we will take a question from Judge Bosa.
Briefly is the word.
We still have time tomorrow.
3 very brief things: an answer, a question, and a placing on the record. The answer to the question about Article 4.2, the court sends investigators onto territories of other states. It sends officials of its own, of the court, onto the territory of other states, e.g. in Libya, where those officials unfortunately ran into trouble. Article 4.2 is about that. Article 87.5 is about that. If a state is asked, a state party is requested to let an official of the court onto its territory and says no, That's Article 87.5. And it's striking that the prosecutor never once mentioned Article 4.2 until prompted. Second point, a question. If the exercise by a requested state of its judicial and police powers in the latter first, arresting and then surrendering to the court a person wanted by the court, is not an exercise by that state of its own jurisdiction, why is Article 98.1 in the statute? The final point, placing on the record Chapter 14 of my estimable tome, International Criminal Law, Oxford University Press, 2015. Where all good books are sold, I stand by that. If you think that's a commercial plug, I have no commercial sense whatsoever, which is why I'm appearing at my own expense here as amicus curiae.
Now, let's, Mrs. Tladi, can you make the point in 1 minute, please? And then after that, we need to take a question from Judge Bosa.
Well, I'll certainly be able to make it in 1 minute because the first part of the statement has already been made. It was this interpretation of Article 4.2. But the second point would also be that to accept the interpretation would actually suggest that when a state exercises its jurisdiction as the court, then it would not be responsible. But the reality is that if you look at the Articles of State Responsibility, the exercise of jurisdiction would be conduct by an organ of a state. So it's not clear how it would be anything other than that state. That was the second point I wanted to make. Thank you very much.
To speak to 4.2, yes, please.
Yes, Mr. President, I'll be brief as well. I think we would associate our thoughts with the last two speakers, but if I could just follow on by reiterating that when one goes to paragraphs, Articles 59 and Part 9, it's quite clear that the national laws and procedures of the requested state are fully functioning, and that that requested state can do things that this court is not looking for: provisional release of the person requested, or refusal to provide documents that are being requested. It's all very clearly spelled out in that regard. And in particular, you might want to take note of Article 90, which is on competing requests. So a request is sent by the court to the custodial state, a request comes in from another state. How do we handle that? As it turns out, it's quite clear in paragraph 2 that an important issue is whether that requesting state is a state party, in which case the court wins, if you will. But in paragraph 4, if the requesting state is not a state party, then the custodial state can uphold its obligation to that third state. So this to us suggests that it's not, the national authorities acting as a proxy. And one final thought, that differentiation between a state that's a state party and a state that is not a party is quite important for the interpretation of Article 98, where the word is a third state, not a non-party state, which is the way that the prosecution wishes to interpret it. A third state, which would include either a party state or a non-party state.
Thank you very much.
Your Honor,
Judge.
can I say 10 seconds on 4.2 and then I'll sit down?
Let's not do that. Thanks.
Let's not do that.
Later. These are very involved issues. We know that. And let's, tomorrow, there will be opportunity for closing speeches, and anything that's burning in the mind that hasn't been said, we can use that opportunity as well. But for now, Judge Bowser.
Thank you, Mr. President. Good morning, everyone in court. My question goes to Jordan. We've been told here, and I stand to be corrected if I'm wrong, that when the United Nations Security Council made resolutions referring the respective situations in the former Yugoslavia and Rwanda to the ad hoc tribunals, respectively, these had the effect of displacing immunity relating to official capacity, even for sitting heads of state. And the provision I've been able to trace in the statute of the Tribunal for Rwanda is 6.2, which reads that the official position of an accused person, whether as head of state or government or as a responsible government official, shall not relieve such person of criminal responsibility nor mitigate punishment. We've also been told by one amicus that the words "cooperate fully" used in those resolutions also displaced immunity. Now, these resolutions were accompanied by statutes. So you could say that the resolution happened first and the statute followed, or they came at the same time. Now, in the present case, there is an existing statute which has a provision in Article 27 which appears to be even stronger than Article 6.2 and the equivalent in the ICTY statute, because this one has two limbs. It has 27.1 and 27.2. And they all talk about, and at least 27.2 is specific that immunities or special procedure rules which may attach to official capacity of a person, whether under national or international law, shall not bar the court from exercising its jurisdiction over such a person. Now, it has also been argued here that the resolution 15 is it 9.3? Yes, also had the same effect of displacing immunity. Now, from a reading of both paragraphs 1 and 2 of that resolution, my question is, does the fact that in this latter position, that is the present case, the statutes predates the resolution, make the effect of the referral any less legally effective, for want of a better word? I don't know whether you understand what I mean. That is my question.
Well, I'm very grateful to Judge Bossa for that question, and I'll endeavour to respond. I think the starting point is that, as we've explained before, the ad hoc tribunals, being subsidiary organs of the Security Council, being established by the Security Council, are really in a very different position to the International Criminal Court established by treaty, albeit with the resolution that we're paying so much attention to, 1593. Having said that, I think the question of head of state immunity before the ad hoc tribunals was not, as I understand it, ever decided. It's, as it were, an open question. There was an arrest warrant issued in relation to Milosevic when he was president, but the actual trial took place later, and indeed he was surrendered by his own state. So I think the situation has never been finally clarified in relation to the ad hoc tribunals. The provision which you read out from the ad hoc tribunal statutes corresponds, of course, to paragraph 1 of Article 27. It's the official capacity provision. So how one is to read that, certainly the ICC statute is clearer in this regard because it has the two paragraphs and it separates out these two ideas of official capacity not being a substantive defence and immunity. So I think the situation when one comes to look at the two sets of provisions, the statutes of the ad hoc tribunals and the statute of the ICC, is really very different. And we don't, unfortunately, have any real guidance from the practice or case law of the ad hoc tribunals because the issue did not arise. The question arose because we got into this debate about implication or necessary implication and the comparison between 1593 and whatever implications there may be in that and the such implications as there may be in the resolutions adopting the statutes of the ad hoc tribunals. We would say, I think, that there's really no comparison between this, and it doesn't assist as in interpreting 1593 to make a comparison with a very different tribunals under very different legal structures, and where the tribunals themselves didn't reach a conclusion on this question of head of state immunity. I've tried to answer that. The key point as well, of course, is that, or a key point is that in our statute, in your statute, we have Article 98, which is quite clear. That is something that was not present or relevant in the case of the ad hoc tribunals, which were UN organs, UN resolutions binding on all states. There was no notion of non-party states in relation to the ad hoc tribunals. And if I could just come back on a point, the prosecution went back to this question of urges, and I do feel we're beginning to repeat ourselves, but I'd just like to repeat myself on that and say there's a very important legal difference between an obligation under a Security Council resolution, which has its effect by virtue of Article 103 of the Charter to override other obligations, including obligations relating to immunities, whereas an obligation under a treaty does not do that. The fact that 1593 did not impose an obligation on states but simply urged them is very significant, because there is no charter obligation on Jordan or on anyone else that would supersede obligations under international law more generally. And if I could just finally, since we're on the urging paragraph, say a word about the phrase, while recognising that states not party to their own statute have no obligation under the statute. Those words, it seems to me, are superfluous. They're there for a reason. No doubt one or more permanent members wanted that to be said very clearly, though it's absolutely clear even without them. It is a statement of the law by the Security Council, but it's a pretty obvious statement of the law that a non-party to the statute has no obligation under the statute, and I can imagine why it was put in. A permanent member, possibly more than one, insisted on that. Thank you.
Well, Mr. Wood, I think that last point is noted. But returning to Judge Boza's question, the distinction, you made that distinction saying the ad hocs were created under Chapter 7, so it is subsidiary. Trying to see to what extent that difference really matters if one considers the effect of Article 13b. Does that not suggest, it's a question, an open question, does that not suggest that the ICC may well be in the position of a court created by Security Council using Chapter 7? The difference being that there was already a court set up, being the ICC, with a corpus of law in the Rome Statute. And all that the Security Council felt it needed to do on that occasion was to, by a process of adhesion, attach the situation in Darfur to the ICC, which makes life, perhaps one might say, easier for the Security Council had it wanted to go to the route of creation of a new ad hoc tribunal, setting it up and negotiating its terms and agreements and all that stuff. Does that difference really matter in the end between the ad hocs and the ICC, if we looked at what Article 13b was seeking to achieve?
Well, I think, Mr. President, it's a crucial difference. I won't repeat what I said about the differences between the ad hocs and this court statute, but they're very significant. The wording is quite different on these matters. We have 27.1, we have 27.2, and above all we have 98. If you look at the statutes of the ad hoc tribunals, they're very different. Coming to your point about Article 13b, I think we've explained earlier our view of Article 13b, and in our view it's very clear from the wording of 13b. The effect of 13b is simply to put within the jurisdiction of the court a situation, more particularly crimes that may have been committed in the context of a situation, and it applies the statute to the court's activities. The court exercises its jurisdiction in accordance with the statute as is stated in the chapeau of 13b. No more and no less. That is our submission on 13b. Thank you.
Thank you very much. In the absence of any more questions in this segment, why don't we then proceed now to, again, we are watching the time for our 11 o'clock postmark of what we needed to do then. But I think we can now begin our submissions on the third cluster, Group C, which you already put on the record. We don't need to repeat reading it onto the record. Judge Banyas has already done that, and whatever he can get into the record for 2 minutes, and then let's all watch the time. Yes, please, Jordan.
Thank you, Mr. President. Perhaps you'll just signal to me if I'm supposed to stop at a particular point. In this presentation, I'll be addressing Jordan's third ground of appeal, as well as the Group C questions relevant to this ground of appeal. As the Chamber well knows, in addition to finding that Jordan failed to comply with its obligations under the Rome Statute, the pretrial chamber decided that Jordan's non-compliance with the request for the arrest and surrender of President al-Bashir be referred to the Assembly of States Parties and to the United Nations Security Council. Jordan strongly believes that the appeals chamber should, in all fairness, set aside the decision on referral. In our view, the pretrial chamber's decision arises from manifest errors of law and fact and amounts to an abuse of discretion. Let me turn first to the circumstances of the visit to Jordan. Question E in Group C asks, what specific actions, if any, were taken by Jordan to communicate to the court the difficulties encountered in its execution of the arrest warrant in respect of Mr. al-Bashir in accordance with Article 97 of the statute. In response,
Okay, I think we've got our 11 minutes. Why don't we stand for a minute of silence? Thank you very much. Please proceed.
thank you, Mr. President. In response to the inquiry from the court regarding President al-Bashir's potential visit, Jordan sent to the court on the 24th of March a note verbal, and we provided a judge's folder for you today. You'll find at item 1 of this judge's folder the March 24th note verbal from Jordan to the court. You will see in that note verbal, which is at item 1, that it provided information about the upcoming Arab League summit. It indicated that invitations had been sent to Sudan, and it stated that Sudan had requested visas, including for President al-Bashir. At the same time, the note verbal indicated that there was no official confirmation that President al-Bashir would in fact visit. On the same day, March 24th, the prosecution filed observations on Jordan's note verbal with the pretrial chamber. And here I would direct you to item 2 in the judge's folder, where you will find the prosecution's observations. The prosecution said that it was not yet clear whether Jordan intended to comply with its obligations under the Rome Statute. And thus, as of 24 March, the prosecution did not view Jordan as necessarily in a status of noncompliance. Instead, the prosecution urged the pretrial chamber to seek immediate clarification from Jordan so as to resolve any question or misunderstanding that may have arisen on the part of Jordan with respect to its obligations. Despite the prosecution's urging to the pretrial chamber, the chamber took no action on that request on March 24th. It took no action on March 25th, or March 26th, or March 27th, or March 28th. Instead, Jordan, on its own initiative, followed up with a second note verbal, this time dated 28 March 2017, and you'll find that in your judge's folder at item 3. This note verbal reported that confirmation had been received from Sudan that President al-Bashir intended to attend the summit. It said that Jordan, and I'm quoting here, Jordan is hereby consulting with the ICC under Article 97 of the Rome Statute. Then it continues, as regards to the content of the arrest and surrender warrants. The note verbal said that Jordan considers that President Omar al-Bashir enjoys sovereign immunity as a sitting head of state, and it said that it considers that the immunity has not been waived by the Sudan. And then finally, it said that Jordan did not think that the Security Council Resolution 1593 contained anything that could be interpreted as a waiver That was the current theory as to why perhaps there was no immunity. This March 28 note verbal to the court was an effort, pursuant to Article 97, to consult with the court. The note is quite clear in saying we are hereby consulting, and it's quite clear in identifying a complicated scenario potentially involving different rules of international law, which, as we know, arise under treaty, under custom, and under a Security Council resolution. And without doubt, Jordan was explaining to the court what it viewed to be impediments to the arrest, to the request for a surrender and arrest, in the form of immunity and the lack of a waiver of immunity. Now, at the time of the events in question, the prosecution immediately recognized this as an effort by Jordan to engage in consultations. On March 29th, the prosecution filed further observations with the pretrial chamber. You have this in your judge's folder at item 4. In these observations, the prosecution unequivocally stated that Jordan's note verbal, and I'm quoting here, formally identifies an alleged legal problem which it communicates to the court by way of Article 97 consultations, end quote. This is the prosecution's own language. Indeed, the prosecution then further acknowledged that Jordan had, and I'm quoting, triggered consultations. Moreover, the prosecution did not view Jordan's position as demonstrating inevitable noncompliance. Rather, when you read the observations, the prosecution again is requesting the pretrial chamber, and here I'll quote, to proceed urgently to resolve any misunderstanding that Jordan may perceive with respect to its obligations under the statute, end of quote. Jordan would have welcomed the pretrial chamber proceeding with such action. Instead, Jordan received no response whatsoever from the pretrial chamber. This, I hope, Mr. President, responds to your question yesterday about whether Jordan had simply and conclusively stated a firm and unwavering position with no interest in reactions from the court. That simply isn't the scenario. Jordan was genuinely seeking consultations, and it was doing so in good faith. Nevertheless, in the December 2017 decision, the pretrial chamber decided to refer Jordan to the council and to the Assembly of States Parties. So allow me to turn now to the standard you should apply in reviewing that decision. As the appeals chamber well knows, a pretrial chamber's decision on whether to refer a finding of noncompliance is a discretionary decision. It's not mandatory. Indeed, this appeals chamber has stated that it will disturb the exercise of a chamber's discretion where it is shown that an error of law or fact or procedure was made. And we have included in your judge's folder at item 5 an extract from the decision you reached in the situation in the Republic of Kenya, and particularly at paragraph 22, you'll see the point I just made. You'll also find that the appeals chamber went on to say that you'll correct an exercise of discretion in 3 broad circumstances: if it's based on an erroneous interpretation of law, if it's based on a patently incorrect conclusion of fact, and if the decision amounts to an abuse of discretion. In any particular case, these elements may be closely interrelated. We submit that what the appeals chamber has to do at the end of the day is to make an overall assessment, having regard to all the circumstances, of the soundness of the pretrial chamber's decision to refer, bearing in mind whether there was good faith on the part of the state concerned. The pretrial chamber's explanation for why it was referring Jordan consists of 4 sentences. 4 sentences. They're found at paragraphs 53 and 54 of the December 2017 decision. We have included at item 6 in your judge's folder the portion of the December 2017 decision where the pretrial chamber discusses the possibility of referral. Although there are a few paragraphs captured in that excerpt, you will see that ultimately there are only 2 paragraphs that speak to why the referral is being made, and this is paragraphs 53 and 54. So that will be at the bottom of the first page of the extract we've given you at item 5 over to the top of the second page. What are these 2 paragraphs saying? Well, the first paragraph, 53, is essentially saying that we are referring Jordan because it didn't comply with our request. I'm paraphrasing, it obviously says a little bit more than that, but in our submission, that's essentially what it comes down to. The second reason, stated in paragraph 54, is that, and here I'll quote, al-Bashir's presence in Jordan in March 2017, at the time of al-Bashir's presence in Jordan, March 2017, the chamber had already expressed in unequivocal terms that another state party, the Republic of South Africa, had, in analogous circumstances, the obligation to arrest President al-Bashir. We submit that these reasons, these 2 reasons for the referral, were based on patently incorrect conclusions of fact and erroneous interpretations of the law. Let's take the first reason. Clear error of fact here. The pretrial chamber, in asserting this first reason, in our view, failed to acknowledge that Jordan was seeking consultations from the court. You see there that, among other things, at paragraph 53, they say Jordan did not require or expect from the court anything further. And that simply is not correct, as a matter of fact. Consultations were sought. The prosecution accepted that that's what was happening, that there was a misunderstanding, that we needed to get back to Jordan, and that's not what happened. Now, the prosecution now, in their pleadings, attempts to paint a picture of Jordan being adamant from the outset that it would not arrest President al-Bashir and that it made no effort to engage in consultations with the court, and that that's the reason why the referral occurred. But as we've explained in our pleadings, and as I just did, that narrative is simply incorrect. Jordan's March 28 note for Ball was an effort to engage with the court. Curiously, the prosecution appears to think it would have been better for Jordan to be less clear about what it thought the legal position was. But in our view, being clear about what you think the law is precisely the starting point for engaging in a consultation as to whether you're correct or incorrect in your assessment. If there was some defect in the way in which Jordan went about its consultations, we would submit it's not of our making. Article 97 contains none of the requirements that the prosecution is now trying to impose on us. It simply provides that a state party shall consult without delay, and we believe that that's what we did once the problem presented itself. The prosecution has also tried to argue that we knew as far back as 2009 that we had this obligation to arrest and surrender based on the issuance of the arrest warrants, but there's nothing in those decisions on the arrest warrants, either in 2009 or in 2010, that's speaking to the issue of immunity, let alone in the context of foreign criminal jurisdiction immunity. So we simply don't accept that as a factual matter one can point to that. Ultimately, Mr. President, it has to be borne in mind that the basic position, legal position, advanced by Jordan in its note verbal, which is that immunity exists for a head of state that is not implicitly lifted by the Security Council, that position is accepted by the pretrial chamber below. They have accepted that this idea of implicit waiver is incorrect. They've accepted the position that Jordan took in March. They've gone on to identify a different legal theory, but the position that was expressed by Jordan is one that the pretrial chamber itself accepts, and therefore we would submit it can't be said that we've acted in bad faith based on the conduct in March. So in sum, we think we were operating in good faith, and it was an error of fact to say otherwise.
Yeah, are you saying then that the theory, that the ultimate theory that was settled upon in the decision was not canvassed or explained to Jordan in the process of the consultation?
Certainly that theory was never explained to Jordan in the consultations for two reasons. Nothing was explained to Jordan by the pretrial chamber in these consultations. There was no comeback from the pretrial chamber. Moreover, the pretrial chamber only attaches to the current theory months after the visit. In July of 2017, in the decision on South Africa, that's where the current theory is articulated. As of mid-March, the current theory doesn't exist. We would also submit that this first reason being offered up by the pretrial chamber in its paragraph 53 was an error of law. And why is that? You cannot refer a state based simply on the fact of noncompliance. The appeals chamber has stated noncompliance standing alone does not result in an automatic referral. Again, in item 5 of your judge's folder at paragraph 49, you'll see that quite clearly being stated. For the pretrial chamber to proceed on that basis, essentially, we submit is a manifest error of the law. And we think Article 87(7) of the Rome Statute is quite clear about this. In interpreting that provision, the appeals chamber, and here I'll direct you to paragraph 51 of what's in item 5, the appeals chamber has said, quote, the object and purpose of Article 87(7) of the statute is to foster cooperation and a referral to the Assembly of States Parties or the Security Council, and here I quote again, was not intended to be the standard response to each instance of noncompliance, but only one that may be sought when the chamber concludes that this is the most effective way of obtaining cooperation in the concrete circumstances at hand. Instead, when you look at paragraph 53, there's no discussion about what it is about the concrete circumstances at hand that would require a referral in order to bring about or induce Jordanian cooperation. And the pretrial chamber itself in the South Africa decision acknowledged that it should be considering whether engaging the external actor would, in the circumstances of the case, be an effective way to obtain cooperation. We've included that at item 7 in your judge's folder. It's paragraph 135 of the South Africa decision. But at the end of the day, we feel that that reason was an automatic referral and consequently a manifest error of law. Let me turn to the second reason that the chamber gave, which had something to do with its dealings with South Africa. Here too, errors of fact, errors of law. Errors of fact, as a matter of fact, the chamber had not, as of March 2017, expressed in unequivocal terms to Jordan that South Africa had failed to comply with its obligations under the Rome Statute. Now, take just what was going on in the South Africa context. As of March 2017, the pretrial chamber is convening a hearing.
5 minutes.
For 5 minutes, thank you. Is convening a hearing with respect to South Africa, and it's only later in July of 2017 that the chamber finds that it has been unequivocally established that South Africa must arrest Omar Bashir and surrender him to the court. So in our view, even vis-a-vis South Africa, there hadn't been an unequivocal expression as to the circumstances of the legality or illegality of the failure to arrest. Moreover, and this is perhaps even more salient, they never communicate any of this to Jordan, right? Jordan is supposed to just be aware of things that are happening in the South Africa context. In fact, when you look at the footnotes in the December 2017 decision, we're supposed to be aware of transcripts of a meeting between the pretrial chamber in South Africa, a transcript that was actually confidential for an entire year before it's made public. So it's very strange to think that this was somehow communicated through to Jordan. Also an error of law in that the pretrial chamber does not explain why dealings with South Africa have any relevance with respect to Jordan. It's quite clear from your jurisprudence that you are not supposed to be taking the circumstances relating to one state party and transposing it to another state party. These are all factually dependent circumstances, and one shouldn't immediately draw a precedent from one to the other, and consequently we would submit an error of law as well. My time is short, Mr. President. I was going to say a bit about abuse of discretion. We think that the comparison with South Africa was unfair and unreasonable. When you look at the South Africa decision, there's a very lengthy discussion of why a referral might or might not occur, and then a conclusion that it should not occur. There's none of that discussion with respect to Jordan, none of the issues about Jordanian law or availability of Jordanian courts or anything. There's nothing that analyzes why it is us, just a few months after South Africa, should be referred. For example, discussion in the South Africa decision about the number of Security Council meetings that didn't result in anything, therefore doesn't seem like we need to do a referral, it's not getting us anywhere. 5 months later, the story changes. Even though nothing additional has happened at the Security Council, we should be entitled to an explanation as to why it is differential treatment is being expressed. And then finally, failure to give weight to relevant considerations. The Chamber doesn't talk at all about our effort at consultations. They don't talk at all about these multiple legal interpretations that have been floating around and whether that should be a factor to take into account as to whether Jordan should be referred, and a failure certainly to consider whether a referral would assist in inducing further cooperation from Jordan. The lack of dealing with these various considerations in our mind is an abuse of the Chamber's discretion, which we believe supports setting aside their decision. There was a question D in the Group C questions that if I have another minute, I'll try to finish up before I'm...
You do have 1 minute,
okay,
4 seconds.
1 minute. Well, you asked the question, it's question D, what circumstances would it be desirable for a referral to be made? It's a good question. We would submit that, you know, obviously you're talking about a state that's a state party. The state, in our view, should be willfully refusing to engage with the court, obstructing things, trying to do something that's antagonistic, maybe not even responding to the court's circumstances of that kind might merit a referral, but not the circumstances that you have before you here. We think that under no scenario should it be the case that Jordan we be regarded as acting in bad faith in its relations with the court.
So your point being there needs to be a finding of bad faith. You're saying it should be dependent on bad faith for referral to be made.
Well, I think it's a number of different factors, but certainly that is a critical component that if you view Jordan as acting in good faith, certainly the referral should not occur.
Well, let's do this. Thank you very much, Mr. Murphy. We'll take our morning break now and then return so we don't break your discussion. We'll adjourn and come back in 30 minutes.
All rise.